Your Lordship,
Yes.
may I make a mention regarding item 7 of part 2 hearing list? With the consent of the other sides, my lord, this may be taken up after vacation, my lord, after a week.
Part 2.
Yes, part 2, item 7.
On the request made on behalf of the learned counsel for the appellants, with the consent of the other side, list this matter after
After vacation, my lord.
after the vacations in the hearing list.
Much obliged, my lord.
Yes.
My lord, I beg to mention item 12 from part 2, my lord.
12.
I am the amicus in this matter, my lord. If the matter may be taken up after the vacation, my lord. It's a conviction under POCSO Act. RI for 5 years,
You want it after the vacations?
my lord.
Okay. The request of the learned counsel, the learned amicus curiae, list this matter immediately after the puja vacations in the hearing list.
Oblige.
Yes.
My lord, and for the respondent number 2, I have no objection to that.
Okay.
Part 2 of item 15, I'm appearing on behalf of my senior. So
Yes.
this matter may be taken after 3 weeks.
At the request of the learned counsel for the appellant, list this matter after 3 weeks in the hearing list.
So like,
Yes.
Daily list for motion, item 1.
Your Lordship, I have inquired about it. Out here, we don't have this Deputy Commissioner of Police border, but he can appear before the Superintendent of Police Narcotics, and he can do the needful.
Will he be able to retain all those necessary details?
Yes,
And
madam.
does he have that, does he have any refugee card or something, those? Now, what I wanted to know was, yes,
My Lord, I humbly request this honorable court to accept an acknowledgement letter issued by the local council of his residence.
now, when a person is not a citizen of India, we would require little more details to track him down in case. Because the president of the council would not take the responsibility of tracking him down in case something goes wrong. So that order that I had given you yesterday, I don't have a copy of it, but you see the biometrics are taken.
Yes, my lord. I think the Superintendent of Police Narcotics can do this needful.
To keep his biometrics.
Yes, madam.
And there is no system of giving them any card, an identity
Now
card.
it's starting, my lord. The process is starting. They are given an identity card. to
So
the
why
refugees.
doesn't he go for that? Why don't you take him for that identification?
Yes,
Give him
madam.
the identity card and
Yes.
let that be the identity proof.
Yes.
Because that is the
can
proof
be
the
done.
state is going to do. Who gives the identity card?
My lord, in every locality, the local council do the needful. But if we direct it before the superintendent of police, he can direct
You give me that piece of paper I had given you yesterday.
this one, my lord.
Please take them. You mark the presence heard so and so, so and so. By preferring this petition under section 528 of the BNSS 2023, the petitioner has prayed for a modification of the condition of bail imposed upon him by the Special Court NDPS Act, Aizawl Judicial District, Aizawl, through order dated 7/6/2024, passed in bail application number 530 of 2024, wherein it was provided that the sureties and the accused shall furnish photocopy of his or her Aadhaar card / EPIC / driving license for proof of identity and residence. Full stop. It has been submitted by the learned counsel for the petitioner that the petitioner is a Myanmar refugee who is temporarily staying in Aizawl, Mizoram, and therefore he is unable to provide the aforesaid documents as his refugee status has preventing him from obtaining the required documents. Accordingly, it is prayed that some other mode of identification of the petitioner may be provided for so that he can avail the benefit of a privilege of bail granted to him under bail application number 430 of 2024 by the learned judge of the Special Court NDPS Act. Full stop. When the matter was taken up yesterday, a request was made to the learned PP to find out as to what other mode of identification can be provided for, since the petitioner would obviously not be in possession of any of the identity cards provided for in the order dated 7/6/2024, full stop. Today, the learned PP has submitted that the SP narcotics would be in a position to take necessary steps for identification of the petitioner by taking the biometrics of the iris of both eyes, fingerprints of both hands, and the photographs, which is also the procedure followed for identification of refugees from Myanmar by the local councils. Full stop. Next paragraph. Keeping in view the difficulties that may be faced by the petitioner to provide the proof of identity and residence, this court modifies the condition number 3 given in the order dated 7/6/2024 in bail application number 430 of 2024 in Vivacon PS case number 410/2022 under section 21C of the NDPS, to the extent that the petitioner accused in that matter you cut it out, is modified to the extent that the SP, the Superintendent of Police Narcotics, would arrange for the petitioner to appear before the local council under such conditions as may be necessary, so that his biometrics of both iris of both the eyes, fingerprints of both hands, and photographs, etc., may be recorded, and an identity card stating his refugee status may be issued to him if that is the prevalent procedure, full stop. It is also provided that the accused shall provide his temporary address, details of his temporary address, and as well as furnish an undertaking that he would not change the said address without prior intimation to the SP Narcotics, and also obtain prior permission from the special judge, comma, what do you call it? Special from the special court, comma, NDPS Act, Aizawl District, Aizawl, Mizoram. Full stop. The process shall be initiated. The process for identification of the accused as aforesaid shall be initiated after the sureties proposed by him submit their sureties to the appropriate court in accordance with law. Anything else to be added?
I think that is.
After the sureties give their surety bonds, then the SP Border Narcotics will take him for identification and all. Till the time someone does not give the surety bond, he is not going. Once someone gives the surety bond, he goes before the SP Border will arrange that he will be taken to the local council where all these details will be taken.
Yes.
He will be properly identified. He will give an undertaking that he would not change the address. And thereafter, the bail bonds submitted on behalf of the accused shall be considered by the appropriate authority to consider his release on bail. The criminal petition is disposed of accordingly. If you find anything more is required to be added, kindly let me know.
All right.
We'll do that before we sign it.
Obliged.
Yes.
Item 2.
Yes.
May it please, Your Lordship, this is a criminal petition for modification of the bail condition imposed by the learned special judge and the NPS Act.
Where is the condition? Page number?
My Lord, if Your Lordship may kindly come to page 208 is the bail order, and the relevant portion is at 209A, my Lord.
209 years.
Yes, my Lord.
What is the condition?
1. The accused petitioner shall execute bail bond of rupees
At
3 lakhs.
page 209A.
9A, my Lord.
Okay, and
Rupees 3 lakhs with 2 sureties who shall execute the same amount of bond. And 2, one surety shall be a permanent resident of Aizawl living in his her own house, while one surety shall be a permanent government servant, not below the rank of LDC, duly one of the family members of the accused. My Lords, here the problem is that condition number 1 and 2 is my problem. So, my Lords, the petitioners are farmers, from Manipur state. And my Lord, this is the excessive amount in their present situation. And my Lords, with regard to the condition number 2, they can find permanent resident local surety. But my Lords, the problem is a government servant.
A family member.
Yes, my Lord.
They
have
may
no
not be a
connection.
family member, no? Yes. You paying for the state?
My Lords, that DRI, they have a special PP.
Kindly inform, we'll see what we can do.
Yes, we have already served a copy, my Lords.
Inform them again that the matter is will be taken up after 15 minutes. You have the phone number.
My Lords.
You have the phone number of the council.
Yes, my Lords.
Kindly inform him or her that yes, the matter is being taken up. Court requires the presence.
My Lords.
Okay. And what I find interesting is once the arrest is found to be illegal, what is the question of all these conditions? Is it not, Mr.? Once the arrest is illegal, it has to be set aside.
Oh, my
It
Lords.
has to be set aside. How can there be any conditions? Let us
My
see you
Lords,
try
one
and...
thing, he's on leave, my Lord. Mr. Johnny Elton Tauchongda.
Oh, then-
Special PP. I'm sorry.
When will he come back? Find out. If he's come back within the week, we'll fix it tomorrow or day after.
My Lords.
Till when is he on leave?
22 to, he's on leave from 22 to 26 till
Then-
Friday.
Thereafter the vacations.
My Lord.
So what to do? See if he can arrange for someone to appear and take the instructions.
Yes.
Since it's a matter of personal liberty, if it's a writ petition, we would have sent it for after vacations.
Okay, my lordship.
But I'm finding it very difficult to digest that once the arrest is found to be illegal, how do you impose conditions on the release? It has to be simply set aside. Anyway,
My lords,
Yes.
maybe day after tomorrow, I'll try to contact, even if he's junior also.
get someone to appear, we can do something else. It is submitted at the bar that the special PP appearing for the Directorate of Revenue Intelligence is on leave, and therefore there is no representation on behalf of the respondents of the Directorate. The counsel for the petitioner prays that the matter will be taken up day after tomorrow for consideration again. List the matter on 25 years.
Highly obliged.
For admission, item 3.
May it please Your Lordship. The main grievance of the petitioner is regarding the decision of the respondents in not counting his initial officiating service as well as contractual service towards seniority and for other benefits, especially when she had applied for the benefits under the MSCP scheme. Your Lordship, initially, the petitioner was, in fact, she is holding a Bachelor of Pharmacy degree as per the requirements of the...
Just 1 minute. Who's appearing for the opposite side? You are ready with the matter?
Yes, my lord.
Ready with the matter?
Yes, my lord. I'm
Okay.
ready with it.
Your Lordship, respondent number 4 is on lecture. The counsel for respondent number 1 to 3 is on leg in courtroom number 1.
She's coming, my lord.
She'll be coming.
And you are appearing for respondent number 4.
Yes, my lord. I am for the institute, Repans. That is there.
The respondent number 4 has filed the affidavit in opposition for
Yes, my
both
lord.
For both.
1 and 1, 2 and 3 and also 4.
Yes.
Is what I
Because
find.
respondent 4 is under the ministry. Respondents
The
1.
stand taken by them is the same.
He has sworn the affidavit in opposition
Yes, my lord.
for the ministry. So the
Yes.
stand also, you can also guide us through the stand taken by him.
Yes.
Yes.
So, Your Lordship, if I may, initially an advertisement was issued by the respondent number 4 on 29th of July 2000, which is at page 15. If I may take Your Lordship to page 15, annexure 2. An advertisement was issued for filling up the post of lecturer of pharmacy, one post, at serial number 2. And according to the third column, the qualification is M Pharmacy or B Pharm with 3 years teaching / professional experience.
Okay.
And accordingly, Your Lordship, the petitioner had also applied. And the selection committee was held on 29th of November 2000, which is at annexure 3. The minutes is available at annexure 3. These are the proceedings of the staff selection committee held on 29th November 2000. At the bottom of the page, Your Lordship. If Your Lordship will see at the bottom of the page,
At the same time.
against the post of lecturer. Has Your Lordship got it? At the bottom of the page.
Page
Page
16.
16, at the bottom of the page. Against the post of lecturer, 2 candidates as per the following particulars turned up for the interview. Petitioner is at serial number 1
Okay.
and Srimati Lal Shiatpui is serial number 2. Page 17. Selection committee, after careful assessment, recommended the case of serial number 3, Ms. Lal Shiatpui B Farm, for the post. Although she had deficiency as per the eligibility criteria with special importance on professional experience for 3 years, after having duly qualified in B Farm, she is having only 1 year experience in 1999. Yet her case was recommended purely due to the difficulties in getting qualified and experienced candidate. At the same time, the chairman was of the opinion that both director of the institute and health commissioner should try to absorb the candidate at serial number 2 Ms. Lalzi Kui, B Farm, who is the present petitioner, within the available avenues. Accordingly,
Why was 3 taken in when one did not have any experience?
Your Worship, in spite of her having, this serial number 2, in spite of her not having the experience of 3 years, she was recommended.
No,
And the reason is,
at Annexure 1,
yes,
the degree was awarded
in
on
99.
7th of October 2020. The examinations were held in 99,
Yes.
but the degree was awarded on 7th of October 2020. And when were the results declared for this? That we would like to know, the results. Okay? Because
Yes.
you see, the advertisement is of
July
July 29th, 2000, and the degree is 7th of October 2020.
Yes.
So on the date of the advertisement, this lady did not have the degree in her hand.
Yes.
She might have had her results only through
Results,
mark sheets
no
and
problem.
also. We
Mark
should
sheet.
know when were the results
Yes.
declared. And because you did not have the experience of even 1 year, the second candidate was recommended and appointed.
No, even the second candidate did,
Did not have it.
Yes. Even the second candidate do not have the experience,
Okay.
but she was recommended, and the petitioner was put in the panel for 1 year.
Yes.
The last paragraph. Accordingly, having found her otherwise suitable, committee kept her in the waiting list for absorption as and when opportunity arises within a year.
Okay.
So within the year itself, at Annexure 4, she was offered the post of lecturer in D Farm on contract basis for a period of 6 months, which is at Annexure 4, page 18.
Lecturer in D Farm.
Yes. D Farm means a pharmacy.
That's diploma in pharmacy. And yes.
So accordingly, she had joined the post on contract basis. Subsequently, Your Worship, the petitioner was given officiating appointment, which is at page 19.
This was for 6 months.
Yes.
And at
And-
page 19,
6 months, it was extendable beyond 6 months also.
for 2 years.
Thereafter, at page 19, Your Worship,
Yes, yes, I'm reading page 19.
she was in excess of
Extended by
past,
2 years. Yes.
and Your Worship will see, as recommended by the staff selection committee held on 29/11/2000, which is at page 16, annexure 3. So on the basis of the recommendation of the staff selection committee, which was held on 29/11/2000, initially she was given the contract appointment for 6 months, and before the expiry of the 6 months, she was appointed on officiating basis in the post of lecturer. And what is interesting is, Your Worship, is that this was given against the vacant post of lecturer, white Miss Binu Singh lecturer, who had been granted study leave,
What we call a leave vacancy.
leave vacancy. But then, if Your Lordship will see,
She resigned.
this lady, Miss Binu Singh, at page 20, she had subsequently submitted a resignation letter, and she had requested that she may be treated as resigning from the post of lecturer with effect from 1st of October 2003, at page 20. So, we can say that the petitioner was appointed against leave vacancy from 12th of October 2001 to 1st of October 2003, for about a period of 2 years. Thereafter, Your Worship, she continued in the post, and subsequently at page 21,
Yes.
At page 21, an advertisement was issued by the respondents, number 5 of
And in the meantime, your appointment
officiating continued.
continued.
Yes.
But there is no such letter as, there is no such order as
There's-
such.
Yes.
Okay.
Then, Your Worship, in 2015, November, this advertisement was issued, and serial number 2, one post of assistant professor pharmacy was advertised. Educational qualification is in the last column. Accordingly, the petitioner had applied, and at page 22, annexure 8, she was appointed on the recommendation of the selection committee against the said advertised post on regular basis.
Post of
At page-
assistant professor.
Yes.
Okay.
Earlier it was lecturer, Your Worship, then subsequently the nomenclature was converted to assistant professor pharmacy.
Okay.
Then, Your Worship, at page 23, the petitioner had submitted a representation requesting the respondents to count her seniority from the date of her initial appointment on officiating basis for enabling her to enjoy the upgradation of pay under the MACP. Which was similarly granted to other colleagues also. But at page 24, the representation was rejected, which is at annexure 10, page 24. If I may read this, Your Worship. Subject application for counting of officiating services / period for the purpose of MACP, seniority and other benefits regarding. With reference to the subject cited above, I am regretted to inform you that your application for counting of officiating service / period for the purpose of MACP, seniority and other benefits cannot be considered due to consolidated guidelines of DOPT issued by OM number so-and-so dated 22/10/2019. Clause 9 of Annexure 1, which states that regular service for the purpose of the MACPS shall be commenced from the date of joining of a post in direct entry grade on regular basis, on direct recruitment basis, or on absorption / re-employment basis. Service rendered on casual, ad hoc / contract basis before regular appointment on pre-appointment training shall not be taken into reckoning. Also, counting of officiating service for MACP and other service benefits cannot be considered unless specifically considered by the selection committee or reflected in the appointment order. So basically, Your Worship, they have relied on clause 9 of the OM dated 22/10/2019. And the extract has been given at page 25. Your Worship. In fact, it has been mentioned, stated also in the impugned letter at annexure 10. Regular service for the purpose of MACPS shall commence from the date of joining a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption / re-employment basis. Service rendered on casual, ad hoc contract before regular appointment on pre-appointment training shall not be taken into account. In fact, this does not include officiating basis. It's a service rendered on casual, ad hoc / contract basis. So thereafter, Your Worship, the petitioner had submitted another representation, which is at annexure 11. And again, annexure 12, page 29, the respondents had again rejected her representation. At page 29, the reason for the rejection is in the first paragraph. This is the letter addressed by the respondents 1, 2 and 3 to respondent number 4. I am directed to refer to your letter number dated 9/5/2022 on the subject mentioned above, and to say that as per DOPT guidelines, officiating period of Dr. Lal Sikh Pui, Assistant Professor, cannot be counted for seniority and other benefits as requested by her. So they are relying on the DOPT guidelines for coming to the conclusion that my officiating period cannot be counted for seniority and other benefits.
Page 27, that first paragraph, what is it? It was proceed with full power for group A officers and recommended made by the selection committee for the purpose. As per schedule 3-4, the selection committee.
Yes, Your Worship, this was a subsequent selection committee, but we could not get a copy of the minutes of this selection committee.
Okay. You want your period to be counted from 2001,
One.
and they are counting your period from 2015. 16 when your appointment took place. Okay.
And Your Worship, what we are saying is that since the officiating appointment was also on the basis of a proper selection process, post was advertised, and I was appointed against a sanctioned post, and I had the qualification required. So the officiating period has to be treated as a regular appointment.
That is your argument.
Yes. There are certain judgments of the Supreme Court which say that when the person is having the qualification required and the post and the appointment is against a regular sanctioned post, even if there is some deficiency in the selection process, at the most it can be treated as irregular. And after the recruitment is regularized, the seniority can be counted. So in my case also,
There is no regularization in your case.
pardon me,
In your case, we do not find a regularization taking place.
Your regularization in the sense that I was appointed on regular basis after proper selection in 2016.
Yes.
And my appointment, officiating appointment from 2001 to 2016 was also based on a selection process against a regular vacant post, and I had the qualification as required by the advertisement. So that period of officiating appointment also can be treated as at the most irregular. And subsequently, 2016, I was given regular appointment after advertisement was issued, and I again underwent the selection process. So that 2001 to 2016 cannot be ignored, Your Worship. It was not that I was appointed through the back door. The post was advertised, and I had undergone the selection process. I had the qualifications, and it was against a sanctioned post. And if Your Lordship will allow me, in fact, in other cases also, the similar situation, the incumbents have been allowed to count their officiating period for seniority and other benefits.
What do you say about this letter at page 29? Para 2. Page 29,
Yes,
para
right.
2. What do you say about that?
With regard to this, Your Worship, I don't think they have done anything in pursuance of these instructions.
No, as per these instructions, the counting of seniority for the other people were also not approved by the ministry.
Refix the same of all employees.
Is it not? By taking away the officiating period is what they are saying.
But Your Worship, as far as my knowledge goes, none of the persons who have been allowed to count their seniority officiating period, nothing has been done to take away the seniority which was given to them.
Okay. Contractual accountant was allowed to. This one in 2006, 2014.
If I may take Your Worship to page 31. If I may take Your Lordship to page 31.
Appoint. This was appointed and then it was regularized. Page 31.
Yes.
Yes, I saw that.
This is
It
the
was an
case of,
appointment on
this is the case of this
officiating basis,
contractual
and
accountant.
in 2014 they regularized it
Yes. And
by taking a qualifying service and up to office in the post of vacant
Para
page
two.
33. Yes. LDC
similarly, Your Worship, at page 33 also,
33 and 34, same person. Okay.
again, another person.
Okay, so you are asking for equality. Equal treatment
Yes,
with
parity.
persons similarly situated. Yes. Who appears for the institute or who appears for the Union of India? Anybody? What
My
does
Lord, I am for the institute.
Yes,
Response-
what do you
respondent
say?
Number 4. My Lord, the main hindrance for not allowing the representation of the present petitioner is at page 24.
Just a minute. You have any judgments to?
Yes, Your Worship. 2020, volume 19, SCC, page 480.
What does it say?
Your Worship, this is a case where the petitioner was engaged on ad hoc basis to the post of junior engineer on white order dated 30th of March 1987. But the post was advertised, he underwent the selection process and he was appointed against a sanctioned post. And his services were regularized on 23rd of November 2002. He was appointed in 87 as JE and his service, he was regularized with effect from 23/11/2002, which is at para 6, Your Worship. Thereafter, he had claimed promotion to the post of assistant engineer by treating his continuous service from the date of initial appointment. But his prayer was rejected, and the Supreme Court, by relying on the two cases which is at para 11, MP Lalit Kumar, if I may read para 12, Your Worship.
Para 12.
Para 11 and 12 are related. In para 11, the case of MP Lalit Kumar was considered, and at para 12, if I may read para 12, it can thus be seen that this court has held that the distinction between irregular appointment and illegal appointment is clear. It has been held that in the event appointment is made in total disregard to the constitutional scheme and the recruitment rules framed by the employer, where the employee is state within the meaning of Article 12 of the Constitution of India, the recruitment will be illegal one. It has, however, been held that where, although substantial compliance with the constitutional scheme as also the rules have been made, the appointment would become irregular inasmuch as some provisions of the rules have been adhered to. Then at para 13, the Supreme Court has considered the case of
ML Kesri.
ML Kesri, and para 14, if I may read para 14, Your Worship. This court in ML Kesri case, held in ML Kesri case that where the appointments are not made or continued against sanctioned posts, or where the persons appointed do not possess the prescribed minimum qualifications, the appointment will be considered to be illegal. However, when the person employed possesses the prescribed qualifications and is working against the sanctioned post, but had been selected without undergoing the process of open competitive selection, such appointments are considered to be irregular. Para 15. Then, Your Worship, the Supreme Court at para 19 had relied on the judgment that direct recruits Class 2 Engineering Officers Association case, Constitution Bench. And at para 20, it has been held, it can thus clearly be seen that the Constitution Bench in unequivocal terms holds that if the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till the regularization of his services in accordance with the rules, the period of officiating service will be counted. So, Your Worship, at the most, in my case also, if we say that I was appointed against a leave vacancy for 2 years, That is the only deficiency in my recruitment, because I was appointed as per the advertisement. After undergoing selection process, I had the qualification. Then I was appointed on officiating basis during the validity of the panel for 1 year against a leave vacancy. That is the only, which is against the petitioner, that she was appointed against a leave vacancy. But in 2003, the incumbent resigned. So from 2003 to 2016, I was occupying a sanctioned post. And then 2016, a new advertisement comes. I applied again after selection process. I was appointed in the same post of lecturer, which has been termed as assistant.
I think you were appointed as assistant professor. Or
Yes, initially these posts were called lecturer.
Now they become.
Now they're, after the UGC norms, it is being termed as assistant professor.
Assistant professor.
Yes.
Okay.
So what I'm trying to say, Your Worship, is that 2001 to 2016, it is not an illegal appointment. It is an irregular appointment at the most. And that period cannot be just ignored. Even in this case, the Supreme Court has held that in this case, this Siraj Ahmed's case, the only reason his officiating period was not counted was because, as per the rules, the appointing authority had not taken the concurrence of the Public Service Commission. Supreme Court held it's just irregular at the most. Taking concurrence of the Public Service Commission can be termed as the most irregular appointment. It cannot be termed illegal. And due to that, he was treated as regular, and as per the direct recruit class 2 engineering case, his officiating period was counted for purpose of seniority and other benefits.
Okay. Yes, sir.
Yes, my lord. I'm referring to page 24 of the writ petition, my lord.
Writ petition.
Yes, first.
Yes.
The main reason why the representation of the petitioner could not be considered is this DOPT's OM dated 22/10/2019, clause 9, my lord. The next page, page 25, the particular relevant page is enclosed here. Rule 9, may I read, my lord, this?
Yes.
At the bottom of the page, last para, my lord. Regular service for the purposes of MSCPS shall commence from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption or re-employment basis. Service rendered on casual, ad hoc or contract basis before regular appointment on pre-appointment training shall not be taken into reckoning. However, past continuous regular service in same or another central government department in a post carrying the same pay level in the pay matrix prior to regular appointment in a new department without the break shall also be counted towards qualifying regular service for the purposes of MSCPS only and not for the regular promotions. However, benefits under the MSCPS in such cases shall not be considered till the satisfactory completion of the probation period in the new post. So due to this reason, my lord, the petitioner's representation for counting the past service as officiating on officiating basis cannot be considered. And my lord, if we look at 2001 appointment as officiating, it is at page 18, my lord. Sorry, my lord, page
19.
page 19. The third paragraph, my lord, the second last paragraph, counting from the bottom. It says clearly that the above appointment is made purely temporary on officiating basis against the leave vacancy and does not bestow on the person any right for future employment whatsoever. And thereafter advertisement was published, floated, in response to that she applied for the post of assistant professor of pharmacy. And she was thereafter appointed, my lord. What I'm trying to say is that it is not by way of regularization, which can also be clearly seen from her representation. It is totally applying, after applying for a new post, the post fresh, my lord. What I'm trying to say is that after applying for the post and when she was recruited, the officiating temporary appointment had stopped, and thereafter she joined the new post. It is not by way of regularization. And while saying that, my lord, I may take your lordship to page 26 of the writ petition. This is her representation. She has also admitted that it is not by way of regularization. Page 26 of the writ petition is her representation. And I may kindly read from, my lord, page, para 3 of page 26. May I read, my lord?
Yes.
Page 26, para 3. That section 21 of the Rules and Regulation Memorandum of Association stated how to appoint employees of the institute as under 21. Appointment of employees of the institute. Appointment of Group A officers of the institute shall be made by the director on the recommendation of the selection committee constituted for the purpose. Power to appoint Group B and C staff shall be vested with the director on the recommendation of selection committee constituted for the purpose. What I would like to mention is that the director also vested full appointing power for Group A officers on recommendation made by the selection committee for that purposes. And as per Schedule 3.4, the selection committee held in the conference hall on 13th May 2011 in their resolution number 2E also recommend myself and Dr. R. Lal Durami for 2 sanctioned posts out of 3 vacant posts, stating as having qualified for the post, the 2 incumbents may be allowed promotion by regularizing their services with effect from the date of joining the post on officiating capacity. That my appointment order was made in contrary to the recommendation of the above selection committee. The recommendation for counting service from the date of joining post on officiating capacity is inadvertently cut off. So by reading this, she has also stated that, my lord, if it is by way of regularization, it was recommended that the past service as officiating in on officiating capacity may be considered.
Then why has it been given to the other 2 persons, the accountant and the LDA?
That is, my lord, it appears that from the...
They have been regularized in service on their same posts
Yes,
because they were working in that post.
yes,
Now the petitioner, she was also working in the post of lecturer.
yes,
But
my lord.
for her, you say that a new appointment process is required
Yes.
and you try to appoint her afresh.
Hmm.
Whereas for the other people, it was a simple case of regularization,
Yes.
which has given them the benefit of their past service.
Hmm.
And this, would you like to argue that the first appointment of the petitioner in the year 2001 was illegal or irregular? Are you
Yes.
trying to say that?
Yes, my lord.
What is it? Is it irregular or is it illegal?
It was not as per the rules, my lord.
Why?
So it is illegal. It
it
was
says
on
that,
officiating basis.
No. What basis you are taking her on is a different, because officiating basis, what is officiating basis?
The recruitment rules, no written, the process was not there, my lord.
No, the process, and as recommended by the staff selection committee held on 29/11/2000. This is something I find that she underwent the selection process. The first 2 lines. See, you do not deny that she has got the requisite qualifications.
Yes,
Selection committee recommended her.
yes,
Therefore, there was some process of selection where she participated.
my lord.
Because that recommendation we find in page 16 and 17, when she appeared for the first, under the first advertisement. Right?
Yes, yes, my lord.
So now she appeared for a selection process. She was kept in the waiting list for the next year, for 1 more year.
Yes,
And within that 1 year, she is given the post
officiating.
on whatever basis, officiating, contractual, whatever, because prior to that she was given on contractual basis at page 18.
Yes,
So that page 18 was then turned into page 20, saying that now you are already a contractual, now we make you an officiating. So your change of terms of conditions from contractual to officiating.
Yes.
She had no control over it. All she could do was continue in service throughout. She did not have a choice, matter of bread and butter. Not in a, what do you say, bargaining position. So whatever you are offering her, she was going on taking it, but she is qualified, she has went through a selection process, and her service has been continuous throughout. There is
Right.
no break. Now, if you come to that notification for MSCP, which page was it?
It was at page
Page 9,
25, my lord.
25, paragraph 9.
9.
Now, you are depending upon service rendered on casual ad hoc contract basis before regular appointment on pre-appointment training will not be taken into reckoning.
Yes.
So, if it is a service rendered either as a casual employee or as an ad hoc employee or on contract basis, for pre-appointment training, that part will not be taken into account. In this particular case, she has not undergone that. Her case is not one of pre-training, pre-appointment training.
I understand.
Her appointment was given. It was not a case of pre-appointment. Then it says, however, past continuous regular service in the same department.
Yes.
So let us take the department to be the Ripans. It is an autonomous body, if I am not wrong. So it is under the Ministry of Health and Family Welfare. So it is a part of the central government, controlled by the central government. In a post carrying the same pay level, she was in the same pay level, in the pay matrix, prior to her regular appointment, in the new department, without a break, shall be counted. So that is why I had put that query. If her appointment in 2001, October or March, whichever time you take, if you say it is irregular, then the scope is different. It is not a regular appointment, so we are not going by it. If that is an argument we wanted to take. Then maybe we'll have to look into whether the appointment was regular or irregular. Can it be termed to be an irregular appointment? But otherwise, somewhere she has had that continuous service under you without a bargaining capacity, taking on whatever nomenclature you were giving her in a sanction post after a due selection process. Everything is there. How can you deny her?
My lord, let me come
When
up-
again,
Yes.
when others have been
I understand.
given the benefit by regularizing their services, they were given that benefit. What do you call blue-eyed boys benefit? I will regularize you, and for you, madam, please come and face an interview and get reselected and reappointed. Is it fair?
In fact, my lord, this is the instruction of the ministry.
Yeah,
And
that is
let me come again to this page 25.
Yes.
Rule 9, my lord. Rule 9, the initial sentence says,
Regular service
regular
shall
service
commence
of
from the date of-
OMSCP shall commence from the date of joining of a post in direct entry grade on a regular basis.
That is what we are saying. Either on
Either direct
recruitment.
recruitment basis or
So
on a
her
job.
recruitment was a direct recruitment for contractual. She participated in a regular sanction post, going through a regular process. Then her appointment on officiating basis was again based on that selection for a regular sanction post.
I understand.
The first sentence itself should be enough for you to have given her the benefit.
Yes, my lord, regarding the query regarding the other two employees
Yes.
given the benefits, maybe due to that reason, this letter, page 29 was issued.
Paragraph 2 has come in.
Yes.
But paragraph 2, you have done nothing about it.
Yes.
They still continue to draw that.
In that regard, I don't have any instruction.
I have my own doubts because you would like to argue that it's a case of negative equality. Someone getting a wrong benefit, another should not get it. Okay, negative equality is one part of it. But then
There's something called equity also. Equality, if you take out the ally, it becomes equity.
Anyway, the most that is what we can do from the institute side. So it is as per the instruction of the ministry that, my lord, we have to convey the
So who's appearing for the ministry?
ministry. The Lance
Yes.
CGC is here. And my lord, anyway, my lord, if I'm allowed to rely on 2 citations,
Please, please. Yes.
I have given to the bench assistant.
Yes.
The first one is 2009 volume 4 SCC 170, para 24 and 25, my lord.
Yes. How does it help you? Which paragraph?
Para 24 and 25, my lord.
Para 24. Yes.
I may read, my lord.
Yes.
Para 25 particularly says it is however also well settled that where the initial appointment is only ad hoc nor not according to rules and made as a stopgap arrangement, the period of officiation in such post cannot be taken into account for considering the seniority.
Now, can you say the first appointment was not according to the rules?
What I'm trying to say is that, my lord, it is a kind of stopgap arrangement. That the leave.
Stopgap arrangement. We are just trying to understand. I'm not
Yes.
arguing against you, or
Yes.
I'm not. I'm just trying to understand. Para 25 has got 3 or 4 conditions.
Yes.
1, it has to be an ad hoc appointment.
Yes,
2, the appointment should not be according to rules.
right.
And 3, it should be as a stopgap arrangement.
Yes.
Now, the stopgap arrangement, if you say could have lasted till the time the other person against whom she was appointed, she resigned. The day she resigned, thereafter, it was no longer a stopgap
She
arrangement.
continued. But
It was at your
Yes.
free will that you did not publish an advertisement to, or you decided not to regularize her. Maybe because the 10-year period was not over by then. But then, unless you have these 3 conditions fulfilled, because it is not an or situation. The Supreme Court does not say that the initial appointment is ad hoc or not according to rules or stopgap. You are not saying that. The Supreme Court doesn't say that. The Supreme Court uses and. So it is not disjunctive, it is conjunctive. All the 3 have to exist together to deny him that benefit. That is how I am understanding
Yes.
it. Maybe you can convince me otherwise. There is no difficulty. I am always open.
Yes, what I'm saying is that, my lord, it was due to the vacancy which was due to the leave.
So you are saying that since it was a stopgap arrangement, he should not be.
Yes.
He would not be. The petitioner would not be entitled to the benefit.
Yes.
Okay.
Another one is the coordinate bench, my lord, of this honorable court. Para 12. I'll not read, my lord.
Para
Para 12.
12. just a minute. I'm just trying to look at another thing. Let me go through the other judgments once again.
This coordinate bench judgment is, my lord, it is in the same line only, my lord. I'll refer to Para 12. Para 12.
12.
12. The same thing it says, my lord, regarding ad hoc and not according to the rules and stopgap arrangement.
And were the facts, circumstances same in those cases also?
Yes, my
Or
lord.
was it a case where the direct recruits were fighting against the promotees?
Yes, this is regarding that matter, but it speaks about the present issue, my lord.
So to give a different meaning of paragraph, you are referring to paragraph 12.
Paragraph 12, my lord.
12.
Para 12.
The law in that kind.
Yes, my lord.
I will produce this situation the initial appointment is only ad hoc and not according to rules and made as a stopgap arrangement officially on such post can be taken as an answer. But every time it is saying not as per rules, not as per rules, not as per rules. And it is not your case that the petitioner was not appointed according to rules. You have never made that statement in the affidavit of opposition. I tried to find out yesterday, but I did not find that sentence. That it was an illegal appointment in any manner.
And
Or
at
it was
least-
irregular.
at
It was
least
only
the
the only stand is it's a stopgap. We are not doing it.
At least the issue of stopgap, that is what.
Huh?
The issue of stopgap arrangement. It was clearly written in the.
See, every time they are saying that because all these cases that you are citing, I did not go through this case, this Likharina, but otherwise, the law as I understood was that anything in service law, anything not done according to rules, will not be taken into account while giving him a benefit. Now, all the promotions made here were officiating basis promotions where rules were not followed. There was either no DPC done, or the number of vacancies which were available was not taken into account, the bifurcation of the post for direct recruitment and the promotees for consideration for promotion to a higher post was not taken into account, the quota was not taken into account, the eligibility criteria was not taken into account, or the DPC did not function properly. These are all those cases, if I understand correctly. In those cases, since there was an inherent illegality in that promotion itself, of entering into that post, therefore, the officiating part will not be taken into consideration while going for seniority. Is what I understand.
Yes.
So now, by the time he replies, you may have some other convincing thing to say to me, and we'll try to look into that also.
Yes, well,
But as of now, this is what we feel.
yes.
Anything
I
else?
understand. I'll conclude that.
Okay. Yes, madam.
My lord, I filed my affidavit on 11
Yes.
2025, my lord,
Yes.
at Para 9. If I may read, my lord, that the statement in para 14, 15, and 16 of the writ petition is denied. However, the answering respondent stated that as per clause 9 of DOPT issued right memo number so and so dated 22/10/2019, which stated that regular service for the purpose of MSCPs shall commence from the date of joining of the post in direct entry grade or regular basis, on direct recruitment basis, or on observation. Re-employment training shall not be taken into reckoning. Also, counting of officiating service for MSCP and other services benefit cannot be considered unless specifically considered by the selection committee or reflected in the appointment order. This is our point. Then the extra copy of the clause 9 is enclosed. And next, number 10, my lord, that the statement in para 17, 18, 19 of the writ petition are denied. However, the answering respondent stated that the selection committee, DPC, has an absolute power to make regular appointment, etc., against regular vacant posts to accommodate those persons already holding the post of officiating capacity with retrospective in respect to Group C, as the retrospective appointment did not supersede the seniority of other appointed in the same gather / post. And whereas the petitioner is not recommended by the selection committee, DPC, at the time of holding the officiating for retrospective appointment. Hence, her case cannot be considered by the ministry at this belated stage. That is
So
our
you are
stand.
pushing the buck to him.
Yes, my lord. At the relevant time, they didn't. The selection committee didn't say anything. That is our stand, my lord.
Are you referring to any judgments? No.
No, my lord. That's much.
Yes, sir. Again, it comes back to you. See, central government says that the DPC should have done it. You have not given any reason why the DPC did not do it. In fact, there is an allegation in her representation saying that the DPC had recommended.
Yes.
Did you find that sentence? She makes that allegation. And you do not answer to it. If you come to that, where is your representation? That
Presentation
longish
of
one?
the petitioner is at page
Longish one, the second one.
26, my lord. Page 26 of the writ petition.
26. Yes, page 27, if you come to the first paragraph, that is what I was trying to
My
understand. As per Schedule 3.4, the selection committee held in the conference hall on 13th of May. Do you have it?
Yes, my lord.
The selection committee held in the conference hall on 13th May 2011 in their resolution number 2E also recommended myself and Dr. So-and-so for 2 sanctioned posts out of 3 vacant posts, stating as the 2 incumbents may be allowed promotion by
Regularizing.
So the selection committee had regularized.
It is not regularizing.
No, I'm sorry, the selection
Yes.
committee had recommended the
Yes.
regularization, but the director or the appointing authority does not say no also. There is no reply to it.
So if it is by way of regularization, my lord.
Now that is one question in my
Yes.
mind which I am going to put to him perhaps.
Yes.
That it was her choice to appear in a regular selection process. It was your choice to appear in that interview or the advertisement. When you had all the authority to come before appearing in that interview to say that, look sir, I need a regularization in that post. And when others have been regularized, so should I be. And when there is a selection committee recommendation in my favor. But then you gave it up. You said, okay, I'll take a fresh appointment. And you took the fresh appointment in the year 2016. 16. And then you made the first representation in the year 2020.
2022.
2021.
21.
So you waited for another 5 years. And affording you a seniority now, one another step that you may have to convince me on is that now at this stage, after being appointed in 16 and then 10 years down the line, refixing your seniority will hamper third party rights who are not before this court. May have the potential of hampering third party rights. We do not know. You have not given the seniority list. We do not have the facts before us.
Well, but the representation was basically for counting of past service for the benefit of MSCP.
But that will not be difficult.
Yes.
Counting of past service for the purpose of MSCP may not be difficult. That is one aspect of the matter that we may look into with a different eye.
Yes.
But so far as your claim for seniority,
That I understand. Your
see, 2016 you took your appointment.
Yes.
2021 the first
Representation.
representation. So from 16 to 2025 or to at least 2021, 5 years.
Yes, but we can restrict.
We
the
don't know
prayer.
the seniority list now prepared. If there are some people who were appointed in the interregnum,
Yes.
when you continued in the contract basis, they are not before the court. How can we touch their seniority?
Basically, we restrict our prayer to the grant of upgradation under the MSCP.
MSCP then, you joined your service in 2001. First MSCP was in 1998, 1997.
1999, I think. Under the
It came into effect, it was published in 1999, but the effect was given from 1997. 2001, yes, 2000. So for the purposes of MSCP, I think it is within limitation.
Time.
It's within the same year. 2021 would be 20 years, second MSCP.
If I may, my lord, however, the writ petition, the prayer is with regard to the seniority
The seniority part, I
and
don't
other
think we can
benefits.
consider. That perhaps you will miss
The
out.
normal court can modify it.
If the
To the
prayer is
extent.
limited, then
And regarding just one short reply, my learned friend has relied on 2009 volume 4 SCC regarding stopgap appointment. It is not the case that my officiating appointment was stopgap. In the affidavit filed by them, nowhere has it been pleaded by them that the officiating period from 2001 to 2016 was on as a stopgap arrangement.
15 years stopgap, how can you believe that? Difficult to believe for 15 years it's a stopgap.
it's a long stopgap.
Yes. So we will consider whether we can have any relief for the MSCP.
MSc.
But seniority, I don't think we can touch.
I understand.
So you are challenging the letter dated 2/12/2021. Where is that? 2/12/2021 is for MSCP. It includes MSCP and 2/6/22. No. 2/6/22 is what? Huh, 2/6/22 is denying you the
As per the guidelines, again, they have denied me. Officiating service cannot be counted.
and 16 June is just the communication letter.
Yes. The decision was conveyed to me.
You were entitled in 2021. You filed the writ petition in
23. Sorry, 24.
24, 4th of September. Okay. So, Tuesday. We'll keep this as CAV. We'll try to deliver the judgment before we go. We'll try to release it. And if time does not allow, then we'll have to do it during the vacations by VC or something. है ना? So,
I'm obliged.
we'll keep it as, or should we say disposed of and release it after a few days? You look at a printed copy of the judgment. Show it as disposed of, we'll do it. We'll do it, disposed of.
Much
We'll
obliged.
dispose it of.
Much obliged.
Yes.
Item 4.
May it please Your Lordship.
Yes.
By way of filing this appeal, Your Lordship, we are challenging the order dated 5/7/2023 passed by the Court of the Senior Civil Judge to Aizawl in Heirship Certificate Application number 911 of 2023, whereby the LSC left behind by our father was issued in favor of the respondent. Our main contention is that there was material suppression of facts. What happened is that, Your Lordship, the present appellant and the respondent are now deceased, and this case is being filed in the representative capacity represented by the respective wives. The facts of the case, Your Lordship, is that we are both children of our father, Mr. K.T. Khuma, who passed away on 14/4/1998. After the demise of our father, Your Lordship, we approached the Lok Adalat.
You were two sons.
We were both sons.
You are both. Your two sons. The two sons are fighting against each other.
No, initially it was between all the siblings. We were 4 in number
4.
initially.
Then
So after our father passed away on 14/4/1998, we approached the Lok Adalat, and Lok Adalat via its 1998.
14/4/1998.
Yes.
Okay, Lok Adalat. Then
So after that, after some small dispute here and there, our case was referred to the Lok Adalat. And in the Lok Adalat, we came to a amicable settlement.
Okay.
This is at page 20 of my memo of appeal.
Page
20, Annexure 3.
Yes.
This is the terms of settlement. And this is dated 18/10/2000.
Okay. So you were 3 sons
Yes.
and 1 daughter.
Yes, Your Honor. So the present appeal is concerned with the first LSC. This is Land Settlement Certificate number 17 of 69 at Bungkon area, the first one which is mentioned. The respondent is Mr. Zosang Zwala's share, the first name. Whereas the present appellant is the last one, Arzo Moya's share, the
This is
fourth name.
appellant and Zosang.
Zomoya.
Huh?
Arzo Moya.
No, that is, he is the appellant.
Yes, Your Lordship.
And Zosang Zwala is the
Respondent.
respondent.
So, within this LSC, within this property is a multi-storied building. So each floor was divided between the brothers and sisters. Now, at the bottom, Your Lordship, I will not read out the respective shares, but at the bottom, Your Lordship, may I read, Your Lordship? As the LSC 17 of 69 is mortgaged at Zitco, Arzo Moya will contribute 25% towards the repayment of the loan. The said LSC number 17 of 69 shall then be kept under the custody of Arzo Moya, and the LSC 17 of 1969 shall not be disposed of or changed in any way without first obtaining the consent of all the parties concerned. That is the term of the agreement. So from 2000 onwards, till 2025 of February, all of us have been enjoying peaceful possession and enjoyment of our respective share within the property. Now, and this Lok Adalat has not been challenged by any party or anyone till date. So this is still holding the playing field. Now, the appellant, the instant appellant, died on 30/12/2017. 30/12/2017, my death certificate is annexed at page 18. 30/12/2017.
12/2017, yes.
And the respondent herein passed away on 15 November 2024, last year November.
Okay.
So after his demise, Your Lordship, the wife of the respondent called for a family meeting sometime in February of this year. And she read out an alleged will executed by the respondent, wherein we came to learn that the portion of the LSC which was our share has been distributed amongst his wife and children.
The will is of Zosang Zwala.
Zosang Zwala.
Okay.
So the will was just only read out, and we were in utter shock and disbelief, we just left the family meeting. And even at that point of time, we were unaware of the fact that an heirship certificate has been issued in favor of the respondent. So after that, Your Lordship, we did some inquiry and we did some checking with the records. That's when we came to learn that heirship certificate was obtained by the deceased respondent sometime in the year 2023 without issuing any notice.
Where is that?
Their application can be found at page 30/30 Annexure A. Now, from the application itself, Your Lordship, the grounds for applying for the the heirship certificate was that he was the sole surviving son of the late K.T. Kumar, our father. Factually, that is correct at that point of time. But as can be seen from the application, there is no mention of the Lok Adalat award. They have suppressed that material.
What about the other son? There was one more son, Zothan Puya. When did he expire?
Zothan Puya is still alive, Your Lordship.
Alive. So this application does not refer to him.
Does not refer to him, does not refer to me.
Okay.
Normally, the normal procedure, Your Lordship, out here is that whenever an heirship certificate is applied for, normally notice by way of newspaper publication is affected. That was not done in this case. In any event, there is material suppression of material fact. There is no mention of the Lok Adalat award.
Okay.
Out here, they have simply stated that I am the sole surviving son, and there is no mention of the Lok Adalat award, and as such, I am entitled to the entirety of the LSC, of the entire property, and which will definitely would include the building. Now, Your Lordship, I would like to take Your Lordship's attention to page 29, the previous page.
LSC is what you say is the land settlement certificate, right?
Land settlement certificate gives you the transferable inheritable rights.
Yes. No, land is settled settled with you, land settled. We call it the patta. All right.
We have something called periodic patta, so that is slightly different from
A
LSC.
little bit different. Okay.
Yeah, but periodic patta out here is issued for a limited period of time, whereas LSC is transferable inheritable.
Our pattas are usually unlimited.
Okay.
There is a settlement system also, but otherwise it's unlimited. Okay, anyway.
Anyways, Your
Yes.
Lordship, at page 29,
29.
the previous page, Annexure 7.
Yes.
As can be seen, Your Lordship, the date of order is 5/7/23. In the next page, at page 30, at the top right corner, Your Lordship, it was registered on 5/7/23.
Same day.
Same day.
Okay.
So number one, Your Lordship, there are three grounds. Number one is that the Lok Adalat award was suppressed. Number two, in the Lok Adalat award, which they have never challenged, it has been clearly stated that any portion of LSCs will not be changed without the consent of the other parties.
We will not go into what was written there, but it was not stated is the main thing.
And lastly, of course, natural justice. So
You will
those
not-
are the facts of the case, Your Lordship. And there are catena of judgments regarding that fraud.
Where is that this, you are challenging this airship certificate?
Airship certificate and the order allowing the airship certificate. Airship certificate is at page 33. And lastly, Your Lordship, I would like to take Your Lordship's attention to page 34, Annexure 10. This is dated as recent as, I mean, not so recent, but in 2010, 10 years after the Lok Adalat award, they had, all the parties signed a joint representation to the member secretary Lok Adalat saying that so far as the remaining portion of our late father is concerned, we will settle it amongst ourselves without troubling your good office. So in other words, even in 2010, they have still acknowledged the existence of the Lok Adalat award, meaning to say that they cannot say that, oh, I did not know about it.
Now, why is the respondent Zozan Zwala?
At page in 34, Your Lordship. In page 34, his name is at serial number 2.
Acha, he during his lifetime he had taken this airship
He passed
certificate.
away in 2024, only last year.
Understood. So now he is represented in this appeal by the legal
Wife.
heirs.
By his wife.
Where is the memo of party? Okay. Okay. Yes, anybody appearing for the respondent?
I am appearing, my lord, for the
Yes.
sole respondent. Yes, my lord, the reason why my husband, there is the direct legal heir of the deceased Kathy Kuma. The reason why my husband had applied for airship certificate is that that particular land settlement certificate could not be put in the dead person's name. So, my lord, after Lok Adalat award had been passed in the year 2000, my brother, Arzo Moya, who is the appellant's husband, he died in the year 2017. And prior to that, Mizo Marriage, Divorce and Inheritance of Property Act 2014 had been enacted, my lord, wherein it was specifically mentioned that once a person died, the head of the family died, then his properties could be inherited by issuing the airship certificate. So after my brother, my elder brother died, and I was the only, my husband, so to say, I'm talking as the wife.
No, no issues.
My husband was the only legal heir who is the most appropriate person to
There was
obtain
another
the-
brother.
I was the
Surviving.
my husband was the youngest one, my lord.
No, but there was a senior, the youngest one gets everything. I don't think that is the law. See, from what I see in this,
Yes, Lok Adalat,
Lok Adalat thing, there was one Zothan Puya
Zotan Puya.
who's still alive.
Yes, but
You did not name him in the legal heir certificate, in
No,
the
I-
heirship application. Why?
I'm trying to say is that, my lord, I applied for only in respect of the LSE. The buildings, Lok Adalat award had distributed by floor wise, my lord. So it was now, till now we have been occupying as it is, as it was distributed by the Lok Adalat. So it was not the bad intention of my husband that.
Then why don't you come to a compromise with him?
So if
Come to a compromise with him.
by simplifying the matter, if I agree that this heirship may be set aside and quashed and it may be remanded back to the trial court, my lord.
No
So
need, Your Lordship.
the reason why I'm saying is, my lord, I may take your lordship to this particular 2014 act.
Please.
Because there is no dispute. If they are not happy with the heirship certificate, then it may be set aside, so
See,
we can compromise.
See, the
Section-
simple thing is, you don't have a process of mutation or something like that here.
We have, Your Lordship. We have.
I'm
So-
not very conversant with the law.
that's
here.
what
You
I
will
will-
guide me through it.
I will refer to 2013 Land Revenue Act.
Let my
also,
learned
lord.
friend complete. I'll
Yes.
Okay.
make the
Now,
submission.
what were you showing us?
Right to that, my lord, that Mizo Marriage, Divorce and Inheritance Property Act 2014,
Huh?
Section 30. First I'll come to 31. Section 31.
31 page.
I'm using this compilation, my lord. The page may be different.
Inheritance of fathers.
Yes, inheritance of fathers. I will not read the whole provision, my lord. But what I'm trying to say that in the absence of the will, their inheritance will flow, as it is stated under Section 31. So I'll come to the preceding section, 30, my lord, Section 30. Section 30 says jurisdiction of the court. The civil court having original jurisdiction over the area where the legatee resides shall have the power. Number 2 is to grant the probate. I'll leave this. Number 3, to grant heirship certificate in respect of any property as per Schedule 4. And sub-clause 4 is also important. To adjudicate upon any dispute arising out of and within the scope of this act. So
You never raised a dispute.
Yes, there is no dispute, but if distribution has to be made and let it be remanded back to the civil court, my lord.
But then when your husband agreed in the Lok Adalat, in 2010 he admitted the Lok Adalat
Yes,
findings,
there is an admitted
the
fact.
settlement. These two things are settled.
Yes, but heirship needs to be issued. Lok Adalat could not.
Heirship will be issued jointly in your name, if I'm
Yes.
not wrong.
It may be jointly also, my lord. So in
It
order
cannot be, but this doesn't appear bona fide. Although we are speaking of a dead man's
yes.
attempts, but it doesn't appear to be bona fide.
That is what, my lord, if they are not happy with this heirship, and it may be set aside and quashed. But the only way will be if subject to your lordship's, my lord, permission.
All your legal
it
heirs
may be-
apply.
Yes, they may
Whatever
apply.
settles.
No, my lord. Yes.
But then it can be only done for the portion which was not within the Lok Adalat.
But my lord, we cannot.
Whatever
leave-
you got in the Lok Adalat, that is the area covered by Vijaya Bank and rent arrears, area occupied by Curzon Baptist Church, Til Bethany Baptist Church, residential area now occupied by so and so, and shop area now rented by so and so. Lama Pari, that is the heirship you can call for.
My
How
lord-
can you dispute something which your predecessor had entered into a settlement?
My lord, what I am submitting is that Lok Adalat award, we are not denying this, we admitted it, but this is not the final adjudication, because that heirship certificate needs to be issued in that particular portion as well.
Which
So,
portion?
this flat-wise distribution as per the Lok Adalat. Because Lok Adalat award is there, yes, it can be accepted as a decree also, but on the basis of that, my lord,
Your
heirship certificate needs to
your
be issued.
share in the LSC is the portion covered by Vijaya Bank, the area covered by the two churches, one church, the residential area where you are now staying, that is, I don't know which floor or whatever, and the shop area, the area on which the shop stands.
Right.
That part you get your legal heirship certificate.
Yes, and LSC
And LSC, the land settlement certificate.
may be jointly issued also, my lord.
How can they that
But, my lord,
land
that's-
will be in proportion.
Civil court may do this if it is remanded back to the trial court. Then all the other interested persons, because the other siblings, children are also still surviving.
No, we will
So
not
let
do
them-
that. We will set aside this heirship certificate.
Then by remanding back to the
Why
trial.
should we remand it back? You go and you fight it out whichever way you want, whichever court you want to go. We are setting aside the legal heir certificate. That's it. Allowing the appeal by setting it aside.
Then liberty may be given at least.
Because
So that we
if we remand it back, the application that your husband made did not contain their names.
No, by, there is what, my lord, this is.
You did not file a suit. You filed an application for a legal heirship certificate.
Airship application. This is the practice we are doing, my lord. Although with
No,
the
no,
lordships, I may take a.
You will have to
Yes.
explain. Yeah, I'm
Yes, yes, my lord. I may
please,
take a lots of indulgence by mentioning
please,
this.
please.
The practice we are doing is that generally we use, because we don't know, initially we don't know who will contest the airship certificate. So generally what we used to do is that we file the airship certificate in the name of, by arraying the name of the petitioner only, without making any person as a respondent.
Then this
Yes.
the person who passed the order, he will be in trouble
And-
because he issued the certificate on the same day itself. Under what circumstances?
Yes, my lord. So when appeal is filed and it is set aside and remanded back, and by directing that all the interested person has to be, like the siblings, direct legal heirs, others, has to be impleaded. And we implead, and like suppose now, in the present matter also the.
See, this is just prolonging litigation. You know whom to implead and whom not to implead at the first go.
Then if it is remanded back, the present matter also, my lord, now we can implead the present appellant.
The
Otherwise-
application is defective.
Otherwise, my lord, the question of limitation will come.
The application is defective. You have to file a proper application. How can a legal
My lord, by way of suit, normally it is not a suit. It is an application, but it has the form of the civil
rights
proceeding.
and titles cannot be decided by the legal heirship certificate.
Now, as I
Right
have
and
just-
title has to be decided by in a suit.
No, my
This
lord.
was not an application.
In
This is
this
not a claim.
application, it can be decided. The title and the legal heir question also can be decided.
In this application.
In this application. That is what we have been doing, my lord. Because it cannot, if it is a title suit, there is a suit which is outside the purview of this particular act. But it has the quality and nature of the suit. Although we have nomenclature as an application, my lord. That is what we are practicing.
If that is what is.
Yes.
No, this is under the Mizo Marriage, Divorce and Inheritance of Property Act
Yes.
to grant heirship certificate.
And sub clause 4 also says that to adjudicate any dispute in the sense that, my lord, if any other question ancillary to inheritance is arising, and that particular issue can also be decided and adjudicated by the trial court. So that is what we are practicing. So this is why it may be remanded back, then I will implead, if necessary, this, or not only the particular appellant, but the other children of the deceased siblings also, my lord, so that it can be settled before this civil court as per this particular.
But we are going to
2014
note
Act.
that the settlement before the Lok Adalat
Yes, by.
has attained finality.
But my lord, in
You will
order
not be allowed to dispute
We
what
will
your
not dispute
predecessor did not dispute. Your predecessor was happy with the shops and the place he was residing in and the land covered by the church. He was happy with that settlement.
Yes, I will not dispute that.
So
my
now
lord.
there can be, you cannot go beyond that.
Yes, that can also be in the heirship certificate, in compromise with Lok Adalat's decision, my lord, Lok Adalat's decree, that can be issued. Heirship certificate needs to be issued, because this is what 2014 Act says.
May I make
Yes.
one?
Otherwise, there is no any other document as per law to show that right and title over that particular land, or whether it is in the form of that particular apartment wise, my lord. Heirship certificate is mandated, my lord.
Yes, what do you say?
Number one, Your Lordship, going by my learned friend's submission regarding section 31, inheritance of father's property. In the absence of a will, then you have A, B, C, D, your class 1, class B, class 2, legal heirs. Now the heading itself is inheritance of father's property. Now it is a well-settled principle of law that entry in the revenue documents does not give you title. Now by way of that Lok Adalat agreement or settlement, the entire LSC has been distributed amongst the siblings, amongst the children of KT Kuma. As such, it no longer becomes the property of our father.
No, the will which the petitioner's husband had made, which was read out to you and you were
Yes,
shocked.
which they
That
were-
will have no force of law.
Correct.
Because he did not have power over
Correct.
that.
So I'm here to
particular
make
property.
one small suggestion, Your Lordship. There's a
When the
way out.
airship certificate goes, if the airship certificate goes as it exists today,
Their airship.
yes, their airship certificate goes, the entire matter is remanded back to the trial court.
Remanded for what, Your Lordship?
This application that they have filed, whatever grounds you have to take, whatever grounds you have to take regarding.
Regarding that, Your Lordship, may I make one? Let me just complete my submission, Your Lordship. Unfortunately, there is one fact which I have not brought on record, which was not informed to me by my client in the beginning. It was only last week that she informed me that they had already obtained an airship certificate in respect of the LSC prior to the respondent. But in our case, we have applied for airship certificate of that LSC, only that portion that was given to us by
That
the
is what I'm- that
Lok
is-
Adalat.
that
So
is what-
let me just, if I may, Your Lordship, if I may. There is a solution in my humble opinion, Your Lordship. There is one solution. So as can be seen, the share of so and so, as mentioned under in so and so, as per the Lok Adalat terms, we have applied this airship certificate. Unfortunately, this was not informed to me by my client previously. So number one, his airship for the entirety of LSC, this comes in the way, number one. Number two, natural justice. Let's forget about the suppression of material facts also. Even on those two grounds, it has to be set aside.
Yes.
So without remanding the matter and getting things too complicated, let them apply for a fresh certificate, filing a fresh application up to the extent of what is their share in the Lok Adalat agreement. Thereafter, Your Lordship, there is one way out. If I can take Your Lordship's attention to the Mizoram Land Revenues Act of 2013. There's a very, very simple solution to this, without troubling the court, without having to have all those years of litigation.
Yes.
If Your Lordship can kindly turn to section 113.
113.
Record of rights of multi-storied building. And for the record, I would like to mention that this act came into force in 2014. At 113 subsection 3, if the inheritors or transferees of such storied property have a joint interest in the land, their names shall be entered as co-holders in the records of rights. Very simple, Your Lordship. Let them obtain a fresh airship certificate up to the extent of their share. We will find a joint application to the Revenue Department. Please issue us a joint LSC as up to the extent of our respective land holdings and making the necessary entry.
This will be
Problem
done by
solved.
the Director of Land Records.
Right.
Who will do this?
The Revenue Department.
Revenue Department.
Land and Revenue Department, to be exact.
Yes,
They
sir,
have the
what do you
authority,
say?
they have the power. Problem solved.
While mentioning about this, I may take your lordship to the rules. There is rule is just next to the act, my lord. If it is the same compilation. Mine is at page 130. 130, my lord. The rule 27.
Yes.
Rule 27 is regarding mutation and partition. And I'll skip this part. I'll come to the proviso, my lord. The second proviso. The proviso, second proviso says that provided further that in case of transfer by way of partition or by acquisition of land or gift or exchange, the original landholder shall have to pay the amount of processing fee as stated in the first proviso except by inheritance. An explanation says that for the purpose of this rule, inheritance is permissible only on submission of heirship certificate issued by the competent court or inheritance of will duly probated by the competent court. So why I'm saying is that, my lord, heirship certificate is a must
That's
in
what I'm
order
saying.
to do the partition
That's
and
what
in
I'm
order
saying.
to register in our own respective names.
You,
So-
just like he has done,
Yes.
his client has done,
Yes.
the same heirship certificate you have to get.
Yes. It may be set aside, my lord.
But then,
It is true. But without-
his client did not have a notice of when you applied for
yes,
heirship
he-
certificate.
Yes,
they,
but-
they
but-
also didn't issue
But
any notice.
this is, number one, this is not under challenge.
No,
Number
no,
two,
maybe.
number two is that this is as per the terms of the Lok Adalat agreement, and it does not cause any prejudice to them.
This is the first time I have seen, my lord. we
Even
have
me,
seen.
for that fact. For
So,
that
my
matter.
lord, what I'm suggesting is that this is the general practice of this honorable court. If I'm allowed to bring all the orders earlier passed by this honorable court, because unless it is remanded back, tomorrow I'll produce, my lord. In other similar cases, several cases, most of the cases, my lord.
About
Because about the remanding back the matter, unless it is remanded back, the first question which will come is that regarding limitation period. Because my husband applied within the limitation.
We can take care of the limitation part, but
Yes.
uh,
And
there's a
simply,
simple
my
way
lord,
of
what I'm
letting-
saying is
letting
simply
him apply
setting
his-
aside.
you have judgments which
Yes,
cover this exact case.
yes.
We
Most
have
of,
to-
it is.
tomorrow
have
I'll
to-
produce, my
We
lord.
may agree to the judgments, we may not agree to the judgments, but when he says that exact facts are covered by some similar judgments,
Yes.
propriety would demand that at least we look into it before we pass any orders.
Fair enough, but
So
then
tomorrow-
let's not forget.
Let's have it tomorrow.
My lord,
Oh,
only,
we can do it tomorrow, no problem.
That is
I'll
what he's
produce
saying, he'll
tomorrow.
produce the judgments
We can
tomorrow.
do it tomorrow.
my
no
lord,
problem.
only,
Tomorrow.
only for the purpose of, to the fact that once heirship certificate is issued without issuing any notice, it is set aside and remanded back to the trial court by arraying all the interested persons
See,
as
if-
the
See,
parties.
if that
If,
those
if
those
it is a if he wanted to litigate, then he can stand up and challenge your heirship certificate.
no
We do
problem.
not know
Up
what-
to him.
what-
Up to him.
So therefore,
That is his rights.
it would, everything would come to a quietus. If all your rights, which this court in appeal would not like to do, if your rights are determined, or if your rights are de-alienated as per the Lok Adalat agreement, the agreement that you had come up before the Lok Adalat, if it is done in accordance with that by the competent court of first approach, the civil court, or whoever is the competent authority to give the heirship certificate, thereafter with the heirship certificate you get your apportionment done. We sitting in appeal here can best say that this order is wrong.
Correct. So what I'm suggesting is that, number one is that, let us not forget and lose sight of the fact that our Lok Adalat award is a decree.
That is what I'm saying.
We agreed to
As
that.
per
And-
all those arguments are to be first decided
I understand
in the
that.
court of
I
first
understand
instance.
that. I understand that. What my learned friend most probably will rely on are those cases where notice was not issued. I understand that. I agree. There's quite a number of cases where notice
In the-
was never issued to the.
What relief we grant pursuant to setting aside of the heirship certificate on the peculiarities of this case, including that Lok Adalat decision,
Correct.
will all come into the order once we go through those orders trying to find out.
I
You
agree
cannot
with
decide
that.
it today.
But what I would like
I'll
to
produce
beg
tomorrow,
your
ma'am.
lordship to keep in, just to take care of the fact that they had obtained heirship certificate by suppressing material facts. That cannot be, they cannot deny that.
No, that's not denied. He's saying set it aside.
Yes, it may be set aside.
He's
aside.
saying set it
The
aside.
only question
But
will be
thereafter
remanded
what?
back.
Thereafter, let him apply for a fresh certificate up to the extent of his share. That's all I'm saying.
No need, my lord.
I don't want his share. And he is also saying he doesn't want my share. Where is the
Instead-
compromise?
My lord,
Compromise is already there in the Lok Adalat.
instead of filing a fresh case or fresh heirship application, the most suitable one will be by remanded back the matter, and I will implead all the interested persons, including the present appellant as well. And thereafter, the Rani trial court can adjudicate in
We'll
any
see
manner.
tomorrow you get your
Yes,
judgments.
my lord. Similar
And
cases.
we'll see what we can do
The
about the
general
matter.
practice, my lord, I'll just,
Yes, we have not made up our mind as yet,
yes.
but setting aside, we have made up our mind.
Yes.
Let us see what we do with the
We're on the same
relief that
line.
we can give you to be listed tomorrow.
Much obliged.
Yes.
Item 5.
University. Okay, this is for tomorrow, no?
My Lord, in compliance with order dated 23/6/2025, we have filed our additional affidavit this morning.
This morning.
Yes, my
You'd like to go
Lord.
through it, sir?
I just got it this morning.
Okay.
After the holidays.
Huh?
It may come up after the holidays.
Has to. Who was supposed to file that? Respondent number?
Respondents.
Respondent number what?
1, 2, 3.
All the respondents.
All the respondents.
It is submitted on behalf of the respondents that the additional affidavit has been filed today morning with an advance copy to the letter counsel for the petitioner. The said affidavit, additional affidavit, is not on record. Registry to list this matter again after the puja holidays, along with the copy of, along with the additional affidavit stated to have been filed by the respondents. Petitioners, you'd like to file some reply maybe?
Let me
Petitioners would be, the petitioner would be at liberty to file response to the same if so advised.
I'm okay.
Obliged.
Item 6.
Yes, item 6.
My lord, I seek your lordship's indulgence in to grant me further time, my lord. I am for private respondents 9 to 58. I may affidavit of opposition will be filed within 2 weeks.
Can
my
we?
lord.
Can we, in view of the order dated 182025, we are
My
bound?
lord,
Although the prayer is allowed, counsel in the said respondent is given last opportunity to file counter
my lord,
affidavit.
with
Tell us, from 12/12/2024.
with
Give
within
us
2
one way
weeks.
to overcome a judicial order. It is passed by a coordinate bench. That was the last opportunity.
My lord, the problem is that in different places they have been posted. So at least, my lord, with during this vacation, I'll complete, my lord. We will
How
have
do I overcome the last opportunity? And thereafter it is allowed further 3 weeks time to file counter affidavit, but without fail. Give me a way to overcome this.
I understand, my lord.
Then again the next sentence, before the expiry of the say 3 weeks, respondents may file counter affidavit.
My lord, at least with cost. Otherwise, our chance will be.
Now what we will do is, we will note down that the affidavit has not been filed, and we will not say about closing of the opportunity, we will say that the affidavits have not yet been filed, and otherwise the matter is ready for what? Admission.
Admission.
So let the matter be listed after the puja vacation. In the meantime, you prepare the affidavits, get it sealed and signed, have it ready for filing. On the next day, say, Lordship, I have it ready, please with cost, then we can do something.
I would be so grateful, my lord.
Is it not? Because without their affidavit, they will say we went unheard.
Yes, sir.
Then it's a division bench again. Not on that ground at least. What is the matter about otherwise?
The main thing is, the claim of the petitioners is that they may be included in the seniority list of ward superintendent, which is circulated by the state government. We are working under the Zoram Medical College, ZMC, and they are treating us as a separate cadre altogether. But our claim is that we were appointed by the state government, and we were appointed after a normal selection process. So we cannot be treated as a separate cadre. we should be included in the common seniority list of ward superintendent circulated by the state government.
So then, if that happens, you get seniority over the
Yes.
respondent
Some
number
of
9 to
them.
something. I think they should have their say with costs or whatever.
Mm-hmm.
So you want a cost order today, or you want a cost order on the next
Without
day?
cost, my lord.
Huh?
This time without cost, my
This
lord.
time
if
without
possible.
cost.
Please.
Despite the directions given in the order dated 1/8/2025, requiring the respondent number 9 to 58 to file their counter affidavit within a period of 3 days or 3 weeks as a last opportunity, comma, the counter affidavits are not found on record. And full stop. When a counsel appearing for the respondent number 9 to 58 has submitted that since the said respondents are posted at different locations, it has been difficult to file the affidavit in opposition, full stop. We are not convinced with the explanation given by the given for non-filing of the affidavits by the by the respondents number 9 to 58. Next paragraph. In view of the above, let this matter be listed immediately after the puja vacations in the admission column. In the admission column. Full stop. You want a fixed date?
Yes, my lord. On 9th, my lord.
9th of October.
Yes, my lord.
I'll list this matter again on 9th of October in the admission column.
Highly obliged, my lord.
You can remind the court on that day.
Item 7.
Yesterday we had fixed one matter for today. Which was that? This one? Murmu advocate was appearing. This one, no? 16 years will. Yes.
My lord, this is a jail appeal. I have received the paper book, and if this matter may be admitted and listed for hearing, my lord.
That stabbing matter?
My lord.
The stabbing matter, where he
Yes,
stabbed
yes,
someone
yes,
and he
my lord.
stabs his relatives.
Yes. Stabs his niece
And his own father.
And his father. Yes.
And now the father is supporting the reduction in the punishment.
Yes.
All right, what to do? He's in jail.
Yes, my lord.
So when did you receive the this thing, paper book?
My lord, I have received. I have been appointed in my custody.
17/9/2025.
79, okay. Amicus Curiae appearing for the appellant and the PP appearing for the state, and so PP appearing for the state of Mizoram have submitted that they have received copies of the paper books in the matter and require a little time to formulate their final arguments in the matter. In view of the above and in view of the fact that this is an appeal from the jail, list this matter on. Can we have a fixed date? To your convenience.
My lord, any day after the vacation?
16th?
My lord.
16th of October?
My lord.
Your Lordship, I have some reservations because I have my brother's wedding on 17th.
Okay.
So, Your Lordship,
28th?
sometime 27, 28.
28th on a hearing day?
My lord.
You have hearing days. Tuesdays are hearing days, you know? Okay. The whole week is a hearing day. Okay. 27th, 28th. On 28th of October 2025.
Your Lordship, the case may be admitted.
Yes, my lord. It has not been admitted.
Okay, I didn't notice that. At the top you write, admit the appeal. Then you say that learned so and so have received their paper book and pray for some time for formulating the arguments.
Deeply obliged.
Items 8 and 9.
Your Lordship, in item 9, may I seek another 2 weeks' time for filing affidavit in opposition?
What happened to that, this thing? Item number, there was an order for mediation.
Yes, Your Lordship, that is item number 8. Your Lordship, as per my verbal instructions, the state is willing to refer the matter for mediation, Your Lordship.
Yes. So,
Lordship, these item 8 and 9 are similar case. If one is referred in a mediation, then
both can go to mediation.
Actually, as a petitioner, we are ready for mediation, Lordship.
What was your claim?
Actually, Your Lordship, we are landowners in particular area in Aizawl. So the government is now trying to evict us from the particular area for which this item number 8 and 9 arose, Lordship.
One of the petitioner, there are some private petitioners and I think there are two churches.
Petitioners. And some are charged, Lordship.
Two or one church is there, no?
Lordship.
It has been submitted by the learned counsels appearing for the parties that both the parties are ready to attempt a settlement through mediation. Full stop. Yes, when is the next mediation? Any date? It is ongoing. Okay. Accordingly, at the request of the parties, these matters shall be referred to mediation. Full stop. Do I need to say that the registry will take a perspective? And the registry is directed to take steps to have the records placed before the mediators, along with prior notice to the counsels for the petitioner and the respondents. Full stop. List after 4 weeks, along with the mediation report, or what? How do you do it here? Then you cut out that last part. You say list the matter again along with the mediation report on a date to be fixed by the registry. So once you get the report, parties at liberty to mention on completion of mediation. You can also mention if you want to with the report.
Item 10.
Your Lordship,
yes.
May it please Your Lordship, I am appearing on behalf of the state respondents. This is the second time the matter has been listed. Your Lordship, if I may be allowed 3 weeks' time to file my affidavit in opposition.
Lordship, service upon respondent number 3 has not been completed yet. It's Kala Saito district. So we have taken steps on 28/7/2025, Lordship. And
Respondent
it's been
number?
Number 3. AD card has not yet returned.
You cannot take Dusty.
Lordship, they have a counsel, this Kala.
Have you served a copy?
No, I haven't served them. We have served it through register post AD, Lordship. We have taken steps. But however, they have a counsel, and I've already told them to appear before this honorable court.
If I understand the procedure correctly, if there is a standing counsel, you have to give an advance copy to the standing counsel before you file
however,
it.
Lordship, we don't know that they have a standing counsel before.
Now you know.
Now I know. Yes.
Okay. Miss So-and-so, heard Miss So-and-so, learned counsel appearing for the petitioners. Also heard Miss So-and-so appearing for the respondent number. Who was seeking time?
State respondents 1 and 2, Your Lordship.
My Lord, for respondent number 4, similar prayer.
Okay. Also Miss So-and-so appearing for the respondent number 1 and 2.
and Ms. So-and-so
Respondent
appearing
number
for the
4.
respondent number 4, and Mr. So-and-so appearing for the respondent number 5 and 6, who all pray for 2 weeks further time to file, 3 weeks further time to file their affidavit in opposition to the writ petition. Prayer is allowed. The learned counsel for the petitioner has submitted that there is a standing counsel appointed for the competent authority for land acquisition within bracket CALA. Full stop. The learned counsel for the petitioner is allowed to serve a copy of the serve requisite number of copies on the standing counsel Kala by obtaining due acknowledgement. Full stop. The registry will reflect the standing counsel CALA against this matter at the time of its next listing. Next paragraph lists the matter in the second week of November, along with the affidavits to be filed by the respondents.
Item 11 for orders.
Yes. Yes, sir.
Lordship, this is a matter which was earlier heard and disposed of by this honorable court.
Okay.
And however, appeal was filed, SLP was filed by the Chakma District Council. And the matter was remanded back to this court. And after it was remanded back here, Lordship, they ceased to appear.
They ceased to appear?
They ceased to appear. They have not appeared before this court after the matter has been remanded.
Okay.
And as a result, as per order of this honorable court, we had served a fresh notice upon the Chakma District Council, who are the respondents number 3, 4, 5, and 6. And service is complete now. We have taken personal service upon those respondents. And we have submitted the affidavit to that effect also. Now this matter can be placed for final hearing.
When was the permission for this thing given? The service of notice by Dasti? Is there any order? Is there any order directing
Your Lordship,
the...
it is reflected on
25/7.
August.
25/7
July.
25/7.
2025.
Where is the notice? Oh, yes. Pursuant to the order dated 25/7/2025, you are appearing for whom, madam?
Your Lordship, for the state respondents.
For the state. I was saying in furtherance of the order dated 25/7/2025, Mr. Lalram Zuava, senior advocate, submits that the affidavit of proof of Dasti service upon respondent number 3, 4, 5, and 6.
Your Lordship, 6 is DC Longklai. 6 is DC Longklai, Your Lordship, Deputy Commissioner Longklai.
Why we have taken the step in respect of 6 is that at that point of time and even till date, the Chakma Autonomous District Council was under suspension. The administration was taken over, was given to the Deputy Commissioner Longklai. That was the only reason.
Anyway, Dasti service upon respondent number 3, 4, 5, and 6.
by way of an affidavit filed on 1/8/2025 full stop. It is noticed that the order dated 25/7/2025 had permitted dusty steps on respondent number 3, 4 and 5, and the affidavit filed on 1/8/2025 covers service of notice on the aforesaid 3 respondents, full stop. Notice on respondent number 3, 4 and 5 is therefore deemed complete. However, there is no appearance for the respondents number 3, 4 and 5 today also, full stop. Respondent number 6, you are appearing for respondent number 6, you will be appearing for respondent number 6
Yes,
also?
Your Lordship, 1, 2 and 6.
Ms. So-and-so has already entered appearance on behalf of the respondent numbers 1, 2 and
6, Your Lordship.
6, full stop. Service of notice on all the respondents is therefore complete, full stop. List this matter for in the hearing column. You want it on the weekly list or on a particular date, sir?
In the weekly list,
In the weekly list. In the weekly, in the hearing column, in the hearing list commencing which week?
second week of October,
Second week of October, a week commencing from
13th.
13th October 2025. Yes.
Okay.
Oh, at the top you would write heard Mr. So-and-so, assisted by so-and-so. Heard Mr. Lalram Zuava, Senior Advocate, assisted by? Yes. Yes, next.
Item 12.
Yes.
Your Worship, in this matter we have received a paper book. The matter is yet to be admitted and the matter can be listed for hearing in due course.
NDPS.
NDPS, yes.
What is the ground? Any one particular ground?
Yeah, may I please, Your Lordship.
Huh?
The first and the foremost point is that there was no civilian witness.
Uh-huh.
There was no civilian witness to the alleged recovery of the contraband item.
Okay. The Learned Counsel, you are the amicus curiae or you are appearing? Okay.
Private counsel.
Okay, heard Mr. R. Lalrem Ruata, Learned Counsel appearing for the appellant, and Ms. So-and-so, PP appearing for the state. It is submitted that the counsels have received the paper book and require some time to formulate their arguments, full stop. Admit the appeal, list for hearing in the week commencing 27th of October. The hearing list, we'll put it in the hearing list, week commencing 27th of October. Yes.
Item 13.
Your Lordship, this is an appeal.
An affidavit was also already filed to that effect, Lordship. This IA's application for condonation of 102 delays in
How much
point
delay?
of appeal.
How much delay is there?
102 days, Lordship. 102.
What is the ground taken?
Lordship, in my application, my grounds are specified at page number 3, running from para 3. The first thing is that, Your Lordship, the judgment and order was pronounced on 11/12/2024. However, I had no knowledge about the pronouncement of the judgment and order, as there was some communication gap with the previous council, Lordship. And the execution case was filed thereafter. And I received an order from the execution court in the month of April. At that time, Your Lordship, I first came to know about the judgment of this, the judgment and order, Lordship. And I inquired the matter. On inquiry, the previous council, Lordship, may I read my points here in Lordship?
Yes.
I have specified the points. And after getting know the pronouncement of the judgment and order, I inquired the matter to the previous council, and there was formal information about the judgment and order, Lordship. And thereafter, Your Lordship, I approached the present council, who applied the certified copy of the judgment and order on 8/4/2025. And on 14/4/2025, the certified copy was handed over to the present council, Lordship. So there was an unintentional delay in preferring this present appeal, Lordship. And Lordship, there is urgency in this case.
You are for the, who has filed the appeal? Plaintiff of defendant?
Sorry, Lordship.
Who has filed? Was the suit allowed?
Yes.
Or dismissed?
Lordship, yes. I filed the case in the original case also, Lordship. I was a plaintiff in the original case.
No, the suit was decreed with cost. The suit was allowed.
I'm sorry, Lordship. I was the defendant in the original case, Lordship. Yes. I was the defendant in the original case, Lordship.
Make up your mind whose side are you on. Difficult.
Sorry,
huh? Okay. The third, Mr.
Tilan Siama.
This is item number?
Tilan Siama.
Tilanun Siama. Learned counsel appearing for the applicant. Full stop. Pursuant to the order dated 8/9/2025, the Dusty steps for service of notice upon the sole respondent through Dusty had been taken, and the applicant has filed, and an affidavit has been filed bringing on record the proof of service on the sole respondent. Full stop. However, today there is no appearance on behalf of the sole respondent. Full stop. The Learned counsel for the applicant has submitted. There is no. Before you wrote that there is no appearance on behalf of the applicant. Just prior to that, take down. Did I say that notice is deemed to be complete? You put that in. Affidavit has been filed. Thereafter, you say notice on the sole respondent is therefore deemed to be complete as regards this interlocutory application. Sri so-and-so and counsel for the applicant has referred to the explanation given at paragraph 3 of the application to submit that the delay of 102 days in preferring the RFA was wholly in preferring the RFA is wholly unintentional and beyond the wholly unintentional and beyond the control of the applicant. Full stop. On going through the reasons stated, the delay of 102 days in preferring the connected RFA is condoned, IA disposed of. Then in the RFA you write, in view of this RFA is already registered as 2425, okay. In view of the orders passed in the process and registered AD within a period of 3 working days on the respondent list after 4 weeks along with service report.
Which of like Lordship?
Item 15.
May I plead your Lordship? My Lord, in this case, there is 57 days delay, my Lord, in filing RFA, my Lord. 57 days delay.
But the notice has to go.
Yes, my Lord, first notice has to go. And so far, my Lord, the paper publication, my Lord, I pray, my Lord, paper publication.
On the first day? Why?
Because it is direct for 42 to 43 is, my Lord, this respondent, my Lord. One is, my Lord, DC, my Lord. So it is difficult, my Lord, this, so if it is...
No, you take steps by registered AD. If it doesn't come back, if there is a difficulty in serving them, we'll go for paper publication. Paper publication is an alternative mode when other
yes,
modes...
I understand, madam.
So
I understand.
take
but
a chance.
So far in either
land acquisition matter.
No, my lord, this is damage suit, my lord.
Huh?
Damage suit.
Damage suit for what? What did you damage?
My lord, is due to construction of the road, my lord.
So the land is identifiable.
My lord, it was, my lord, not, my lord. So the damage was not, my lord.
No. What I am saying is the address of the petitioners is identifiable. You know the land they are talking of.
Yeah,
so
yes, my lord, yes. Then
let us go first initially by registered AD. If it doesn't come back, then we will go for paper publication or dusty or whatever you want to.
Yes.
Let us not go by the alternative mode on the first day itself. May not be proper.
Yes, my lord, yes.
Okay. Heard Mr. S.K. Medhi. Should we say on BC? No.
My lord.
Heard Mr. S.K. Medhi appearing for the applicant in Northeast Frontier Railway.
NF Railway.
Full stop. The present interlocutory application has been filed praying for condonation of delay of, where do you find the number of the 57 days in filing the connected appeal.
RFA.
Full stop. In the connected RFA, instead of appeal you say in the connected RFA, full stop, issue notice to the respondents.
It is one respondent.
Okay, you are Mr.
Samuel Vandal Shriyata.
Okay. Take his name. Appears for the respondent number 1, District Collector cum Deputy Commissioner. Full stop. Extra copies of the IAB served upon, as we supplied to the said council, appearing for the respondent number 1 within 3 working days.
My lord, 10 days, my lord.
Supply a copy of the IA, 10 days.
Okay. So what's possible, my lord? Now I am not coming, my lord, so.
Your IA is how many pages? 15 pages. Okay.
Yes, sir. I'll send through WhatsApp, my lord, no problem.
Will that do?
It's okay, man.
Full stop. Within, what did I say? Learned Council, extra copies to IA. Respondent number 1 within 3 working days.
supply of the copies as consented by the Learned Council for the respondent number 1 is also allowed through WhatsApp. Should we say that?
No, my lord, because we'll have to take a printout. You'll have to provide a copy, my lord.
You have to provide a copy.
I'll provide, my lord.
Okay, within 7 days. Within 7 working days, full stop. You cut out that WhatsApp part, okay? The applicants are to take steps for service of notice on respondent number 2 to 43 by usual process along with registered AD within a period of 10 working days from today. List on the
My 28th of my lord, October, my lord, I'm coming, my lord. 28.
You will supply copies within 10 days.
My lord, within 10
23rd, you will
10
supply copies by 6th. Okay, 28th of October 2025 along with service report.
Highly obliged.
So, one matter left. Huh? Easier, no? Okay, then we'll reassemble it too.
Your Lordship, Your Lordship, I know that it's not a time for making a mention. The part 2, item number 2, we were both ready, and but Your Lordship, due to time constraints, if this matter can be taken up next week, because we still have one matter to be heard today.
Okay. You want it next? You want it on the next hearing list?
Next week.
The request of the Learned Council appearing for the state of Mizoram appellant. List this matter in the next hearing list.
Deeply obliged.
So this also one. Okay, we'll reassemble it too. Okay, thank you.